My name is Sarah Kirk, staff attorney with Legal Aid Society. Today I've been asked to talk about 504s and IEPs and what is the difference between both documents. So 504 and IEP, they both help people and students with disabilities in the education system. Yet there are a wide variety of differences between the two. This talk will outline 5 differences between a 504 plan and an IEP. The first difference has to do with documentation. The second difference has to do with eligibility. The third difference has to do with parental consent and parental involvement. The fourth difference has to do with standards of service. And the fifth difference has to do with the procedural safeguards that are available to parents. So IEP stands for Individual Education Program and is governed by the Individuals with Disabilities Education Act. 504, on the other hand, is governed by the Section 504 of the Rehabilitative Act of 1973, which prohibits discrimination by any program against people with disabilities who receive federal funding, which includes public schools. Both laws require schools to provide a free and appropriate public education, abbreviated FAPE, F-A-P-E. Note, Section 504 does not require any formalized documentation, such as a 504 plan. However, typically, to ensure that FAPE is being provided under 504, schools will develop a 504 plan or documentation. So the first difference, as mentioned, is that the IEP has more robust documentation. An IEP must have several sections included in it. The first section is present level of performance, or PLOP, P-L-O-P. This section must include the child's strengths and weaknesses, any parental concerns, and just any information about where the child is right now in their educational progress. The IEP must also include annual goals that must be reevaluated and reexamined annually. The IEP must also include dates and locations of services, such as whether the services will be provided in the general education classroom, the special education classroom, or a mixture of both. They also must determine what environment the student is going to be in and for how much interaction with non-disabled peers is required, whether that be 100%, which is the default position, or a more restricted placement, depending on what would be appropriate for the student. The IEP must also include related services such as OT, PT, and speech. Lastly, if a child is 14 or older, the IEP must include transition services. These services are services that either the local educational authority or a third-party organization, if the parent consents, will help the student with the disability transition to post-secondary life, either college or a job. So those are the required sections of an IEP. 504, on the other hand, has no required sections. The local education authority must implement policies and procedures governing what a 504 document must look like. They may adopt the IDEA regulations. If they do so, a 504 plan can look pretty similar to an IEP. But again, it is not required to look similar. The second difference is eligibility. So eligibility under the IEP To be eligible for IEP, one must be one of the 10 disability categories as outlined under the Individuals with Disabilities Education Act. And that disability category must have an educational impact. Under 504, any disability category is eligible for 504, provided that the disability substantially limits one or more major life activities. So a major life activity is considered to be walking, breathing, standing, reading, and such. There are probably more examples in the regulation. Both require an evaluation to be done. So the school must evaluate for 504. They also must evaluate for IEP. The frequency of the evaluations are different. So for IEP, a school must evaluate every 3 years. For a 504, the regulations are silent on the number or it just says frequently, which is defined again by the local policies of the local education authority. And since those can differ, I can't say what specifically how often a 504 needs to be evaluated. The other major difference is parental consent. Virginia is unique. So under IDEA, every state is required to develop their own special education regulations in collaboration with the IDEA, which is a federal law. So in Virginia, the Virginia Special Education Regulations, it says that an IEP cannot be changed or altered without a parent's consent. That means that if a parent signs the IEP and then refuses to sign next year's IEP, the IEP that they signed is the one that school is required to follow. 504 does not have this provision. 504 plans can be changed and altered without the parent's consent. Parent consent is only necessary under 504 for the initial evaluation. Once the student is evaluated under 504, the school can make any changes to the 504 plan. Also, under the IEP, a parent is required to be part of that IEP team. It's a required member. While under 504, parents are encouraged to be involved in the development and implementation of the 504 plan. They are not required to be by law. Lastly, standards of service. So, under the IEP, the standards of service were dictated by a court case called Raleigh. It's the Raleigh court case. In that court case, a free and appropriate public education was defined as any education that offers a benefit. So basically, an IEP does not need to offer the best education, just as long as they're having some educational benefits from the services and goals that are in the IEP. 504 actually has a much higher standard. Under 504, a student must have the same or equal opportunities as people with no disabilities. In other words, under IEP, a student doesn't need to have the same access to the curriculum as their non-disabled peers as long as they are able to access it and receive an educational benefit. Under 504, they would. They have to have the same equal opportunity. So it is a higher standard. Lastly, we'll talk about procedural safeguards. Under an IEP, a parent has more opportunity for procedural safeguards. If the school violates any of the procedure, a parent has a lot of different ways to address this with the school. The first way to address it is through mediation. The second way is to file a complaint. The third way is due process. Under 504, if a student just has a 504 plan, the only way to really address issues is to request an impartial hearing in front of a judge. Lastly, I want to mention that the disciplinary issues that student participatory face are the same under 504 and IEP, insofar as they have the same rights. What I mean by this is a common misconception is that a student needs an IEP in order to have the same disciplinary rights as a 504, but this is not true. So a student who is facing a disciplinary action by the school, if they are being removed for 11 or more days, cannot be removed until the school determines that the behavior for which they are being removed is not a part of their disability. This is true under 504 and an IEP. I hope this is helpful. Thank you.